If you have a married couple, they really should be filing together. In fact, Section 302 of the Bankruptcy Code envisions a joint petition filed by a married couple. I suppose if the married couple has been separated for a while, they're just not communicating, there doesn't seem to be any connection between the two, they could file separate petitions. But generally that's not as good an idea, in part because you have two separate bankruptcies, so you have twice the cost. And the information in the two petitions will be generally pretty much the same unless the couple has been separated, in which case the income of the other couple doesn't get included in the income of members of the couple who files. Another issue that comes up is the exempting of assets. Now, a person might, or a couple might think, well, you know, if we separate, maybe we can stack the exemptions on the house. That you can't do. If you're filing all by yourself, then you get that exemption on the equity in the house, but the other spouse cannot stack that exemption on top of, so that you get a double counting. That's not a possibility. So there really isn't a good reason to file separate petitions. In fact, it's generally speaking, the thing to do is to file together. Now, sometimes a couple doesn't file together, and there are good reasons for that. One reason is, well, one of the members of the couple simply doesn't want to file. And so there's no law that requires somebody to file for bankruptcy protection just because someone else does. The second thing that comes up, maybe one of the spouses is ineligible to file for bankruptcy protection. For example, if you were to do a Chapter 7 bankruptcy and get a discharge, you can't do another Chapter 7 bankruptcy until 8 years and a day have passed from the petition date of that prior bankruptcy case. So suppose one of the couple did a bankruptcy, and I've had these fact patterns, by the way, in cases that I've represented debtors in. One couple filed a Chapter 7, got a discharge, a year later, got married. 2 years later, the couple has a lot of debt, while the one that did the prior bankruptcy is ineligible to do a Chapter 7, so the other one does the Chapter 7. And similarly with the Chapter 13. Well, Chapter 13, if you've done a 7, it's a 4-year window to get to 13, but it's an 8-year window to get from 7 to 7. The point here is, one of the members of the couple might simply be ineligible for bankruptcy protection. Perhaps they just got married. And the spouse that wants to do a bankruptcy has a boatload of debt. The other spouse has no debt. And I had a situation where the couple had been married literally for a month. And there was no reason for the non-debtor spouse to file. So in that situation, it does make some very good sense simply to have one of the couple file. Now, there is a benefit to this, and that is when you get a discharge, the discharge protects not just you and your income, but any what's referred to as subsequently acquired community property from collection by creditors who were creditors in the bankruptcy case. So you could have a situation, couple is married, one goes into the bankruptcy, the other doesn't. The debts that were listed in this bankruptcy that are discharged, creditors cannot go after the wages of the non-filing spouse because those wages are community property that are explicitly protected from the depredations of creditors. So there can be a real benefit to having only one spouse file, because maybe the spouse that didn't file has a big problem, and there might be a determination of non-dischargeability that would goof it up for both spouses. So the old slogan is, Snow White could file for bankruptcy, and Snow White is married to the devil incarnate. Snow White gets a discharge, and the creditors can't go after the devil to collect those debts. Whereas if they'd filed together, the creditors could have challenged the discharge of the debts based on Satan incarnate's behavior, and then that would have been a real problem. In sum, There can be some reasons for not filing together, but it does not really make sense at all for the couple to file two separate bankruptcy cases.